Ngayong gabi po, babalikan natin yung pangyayaring impeachment. Unang araw guys ng impeachment kanina na nagsimulang alas 2 ng hapon at natapos alas 5 pasado. Nag-live po tayo kaninang hapon at ngayon alamin natin guys ang iba't ibang reaksyon doon sa naganap na unang araw ng impeachment trial laban kay Vice President Inday Sara Duterte. Wrap up muna tayo guys. Ang nangyari kanina ay nag-elect po ang majority ng Senado ng presiding officer. Hindi po ang tumayong presiding officer o nag-lead sa impeachment kanina, alas 2 ng hapon, hindi po ang Senate President na si Win Gatchalian, subalit nag-elect po sila ng bagong presiding officer sa katauhan po ni Senator Chiz Escudero. Guys, kaya ang presiding officer kanina ay wala pong iba kung hindi si Senator Escudero at yon nagkaroon ng pagpresenta o ang tawag doon ay panimula, presentation, panimula ng depensa at prosecution, panimula ng kanilang pananalita sa naganap kanina sa impeachment trial po ng Senado. So guys, wala po nagawa yung minority, yung pag-question ni magkapatid na Cayetano, si Senator Peter Cayetano at si Senator Pia Cayetano, na question nila na dapat ang presiding officer ay ang Senate President ayon sa saligang batas natin. Subalit wala silang nagawa. Nang nagbotohan ay nagtagumpay po ang pagpili nila bilang presiding officer kay Senator Chiz Escudero. So, balikan po natin guys yung pangyayari kanina diyan po sa Senado kaninang alas 2. Ito po, panoorin natin yung video.
If a motion will be filed by either party for the issuance of a subpoena, and we shall await action, if any, by the BR Commissioner should that time come. So ordered. Now, so far as the subpoena requested by the prosecution for the two NBI agents, may I request the clerk of court to kindly read the motion for the issuance of subpoena ad testificando.
The prosecution, to the undersigned public prosecutors, respectfully request the issuance of subpoenas ad testificandum, directing the following witnesses to appear and testify before the Honorable Impeachment Court on July 6, July 7, and July 8, 2026 at 2 p.m. as their testimonies are material, relevant, and necessary to establish the allegations under Article 4 of the Articles of Impeachment, as well as matters necessarily incidental thereto, and for purposes of the identification and authentication of other evidence before the Impeachment Court. Number 1, Attorney Jeremy C. Lotok, Regional Director, National Bureau of Investigation. Number 2, John Mark Calilong, Senior Agent, National Bureau of Investigation. Respectfully submitted, Quezon City for Pasay City, July 1, 2026.
We are not in receipt of any reservation or objection on the part of the respondent, counsel for respondent rather. However, Chair would like to ask the prosecutors, do you only request for a subpoena ad testificandum or a subpoena duces tecum as well?
If I understand the record, Your Honor, please say subpoena both for ad testificandum and duces tecum.
The motion filed by the prosecutors is only for a subpoena ad testificandum. That's why the chair is clarifying.
Your Honor.
I stand corrected, if Your Honor, please. It's just
Counsel
for ad
Correspondent?
testificandum.
Counsel for Respondent?
If I may, Your Honor, just to set the
Please
record
proceed.
straight, the presiding officer earlier inquired mentioned that the court is not in receipt of any objection from the respondent. But just to set the record straight, the respondent has not received any copy of the request for subpoena being mentioned today, Your Honor. What we received, Your Honor, was a manifestation containing the list of the witnesses of the prosecution for July 6, 7, and 8, Your Honor. And so it would be impossible for the defense or the respondent to object or to even comment on a request that we were not served with any copy with.
The two witnesses against whom a subpoena has been requested by the prosecution or mentioned in the pre-trial brief of the prosecution and was not commented on by the respondents in their pre-trial brief. But if you do have any objections now, the court would be more than glad, or reservations, the court would be more than glad to hear it before ruling on the motion for the issuance of a subpoena on
That's
these
fine.
two NBI agents.
At this point, Your Honor, that's fine. We'll just place on record our objections as testimonial evidence is presented.
Duly noted. Chair hereby orders that the subpoena ad testificandum and ducis tecum be issued to the aforementioned two NBI agents contained in the motion filed by the counsel for the prosecutors. Although by nature subpoena is ex parte, we would Chair would instruct the clerk of court to kindly upload all of the filings of all of the parties to the website for the information not only of the senator judges, but also of the parties and their counsels. The chair earlier, counsel for respondent said that witnesses for the succeeding week shall be manifested in open court on the last day of the trial, in this case by Wednesday, insofar as the next week's trial is concerned. So ordered. Now, insofar as the request for subpoena for bank records and AMLC records, Chair recognizes the clerk of court to kindly read and spread into the records the request for the issuance of subpoena, both, I believe, ad testificandum and ducis tecum, or just ducis tecum, for the aforementioned documents. The clerk of court may proceed.
Request for issuance of subpoena ducis tecum. The prosecution respectfully requests the issuance of a subpoena ducis tecum to the branch manager of the following banks: BPI Julia Vargas Branch, BPI Green Hills EDSA Branch, Philippine Savings Bank Wilson Branch, BDO Unibank Inc. Davao CM Recto Branch, Metrobank Davao Ecoland Branch, BDO Unibank Davao Rizal Branch, Security Bank Bikutan Branch, Land Bank San Pedro Branch, Philippine Savings Bank Davao MADR Branch, requiring him or her or his or her authorized representative to submit to the clerk of the impeachment court on or before 24 June 2026 at 9 a.m. the certified true copies of all records, documents, books, papers, electronic data, communications, and information in the possession, custody, or control of the bank relating to any account, deposit, investment, trust, loan, safety deposit, or other financial transactions maintained, open, closed, controlled, beneficially owned, or jointly held by Sara Z. Duterte and or Manasseh R. Carpio, whether individually, jointly with each other, jointly with any other person, or through any authorized representative, nominee, attorney-in-fact, or signatory for the period January 1, 2007 to December 31, 2025, including but not limited to: number 1, records identifying account numbers, account types, know your customer documents such as but not limited to customer information forms and signature cards. Number 2, monthly bank statements, average daily balances per calendar year, year-end balances from January 1, 2007 to December 31, 2025. Number 3, all account and transaction records, ledgers, and journals and similar instruments from January 1, 2007 to December 31, 2025. And number 4, all other relevant bank documents. Request for subpoena juris tecum to the Anti-Money Laundering Council, to Honorable Eli M. Remolona Jr., Chairman, AMLC, to Attorney Ronel U. Benaventura, Executive Director, AMLC, requiring him or her or his or her authorized representative to submit to the Clerk of the Impeachment Court on or before 24 June 2026 at 9 a.m. original or certified true copies of the following. Number 1, all reports of covered transactions and suspicious transactions filed by banks and all other financial institutions and covered persons required to submit covered transaction reports and suspicious transaction reports to the AMLC involving Sara Duterte Carpio and or Manasseh R. Carpio covering the period of 2006 to 2025. Number 2, any and all investigation reports or related reports or documents prepared by the AMLC suspicious transaction, electronic copies including Microsoft Excel files, database extracts, or machine-readable formats of AMLC, CTRs, and STRs for the period 2007 to 2025 involving Sara Duterte Carpio and or Manasseh R. Carpio, respectfully submitted, Quezon City for Pasay City, June 18, 2026.
Your Honor, may I comment?
If Your Honor, please, before the defense makes a comment, just to obviate the proceedings and to facilitate the hearing today, if I may.
The chair has not recognized anyone yet.
May I be recognized, Your Honor?
Yes, the counsel for prosecutor.
If Your Honor, please. The subpoena request that was just read by the clerk of court pertains to a request that the prosecution filed in early June, where we had requested that the documents specified be brought to the Honorable Court on June 24. Since that date has passed and no subpoena has been issued, we had refiled just this afternoon a subpoena reiterating the same requests, and in the interest of justice and to allow the defense to comment or if they want object to the request that we filed this afternoon, perhaps if I may suggest, if Your Honor, please, that we provide the copy to the defense, give them a period of time to submit their opposition or objection, and as well the same period of time to the prosecution to reply before the Honorable Court rules on the request.
Is the motion for subpoena ducis tecum and or ad testificandum that you filed today exactly the same as what you filed before?
No, Your Honor. It contains the same documents that we had requested earlier, but there were some additional documents that were also mentioned in the request we filed this afternoon.
So you asked for additional documents?
Yes, Your Honor.
What is counsel for respondent, sir?
Your Honor, before I give my comment on the request for subpoena, I thank the good counsel for offering to provide us a copy of the request for subpoena, but we would also ask that we be provided with the June 2026 copies of the request for subpoena as well as the new one that the counsel mentioned today. But just for the record, it would seem to me that the request for subpoena covers documents involving years from 2006 up to 2025. And again, just for the record, this would seem to violate the Duterte versus HOR ruling, which very clearly states that the impeachment must be only for those acts or omissions within the impeachable years and terms and office of the official. But nonetheless, Your Honor, just so we're able to fully ventilate whatever objections or comments that we may have on this request, and considering that for today and in the disclosure made by the prosecution, they will begin with Article 4 and all these documents to pertain to Article 2, then we will ask for 10 days to file our comment on this request for subpoena, Your Honor. From today, Your
Chair
Honor.
hereby directs that all motions for the issuance of subpoena ad testificandum, subpoena ducis tecum filed by either parties be furnished to opposing party and or counsel before filing it before this court in order to provide full disclosure and fairness. But instead of 5 days, counsel, chair is giving both parties 5 days to submit their respective memoranda and or position insofar as this is concerned. We will afford the parties time to argue their position before the court so that the senator judges can hear your position in addition to your extended written memoranda insofar as this crucial issue of issuance of a subpoena ducis tecum ad testificandum on certain bank records and AMLC records, which the chair will schedule, giving ample notice to the parties in due time. Is that okay with both sides?
Just for clarity, Your Honor.
Yes, counsel for respondent.
May I ask that the period, if the period for the parties to submit or the respondent to submit its comment, her comment on the request for subpoena would be 5 days from today, Your Honor.
From today, but you can submit it on Monday since it lands on a Saturday.
Second, Your Honor, the presiding officer mentioned that we also must submit a memorandum or position paper on this, Your Honor.
If you so desire, or you simply can argue it in open court,
Okay,
but you may want to submit an extended written memorandum on the matter for the easy reading of the senator judges pertaining to this issue.
Last, Your Honor, will the court also schedule an oral argument on the respective positions of the parties?
Yes, chair will do that.
Thank you, Your Honor. And this would not be on Monday, Your Honor.
No, that will not be on Monday.
Thank you, Your Honor.
If Your Honor,
Counsel
please.
for prosecutor?
Yes. May I be allowed to make a counter manifestation, just a brief one, with respect to the statement of the defense counsel regarding the application of the case of Duterte versus House of Representatives.
The gentleman may proceed briefly.
Your Honor, the decision and the resolution of the Supreme Court in that case did not say that any preterm evidence is inadmissible. There's no statement like that at all in the entire decision and the resolution. What the Supreme Court said, and I quote, was very simple. The basis of any charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. All of the articles in this particular case pertain to impeachable acts committed by the Vice President during her term as an impeachable officer, including unexplained wealth. If I may just be allowed 1 minute, Your Honor, to explain that. The
1 minute.
unexplained wealth, Your Honor, that is amassed prior to the term of a Vice President is relevant and material to her being an impeachable officer because wealth of the magnitude of millions or billions ay meron pa rin pong pakinabang po yan ang Vice President kahit hanggang ngayon. It's very clear that when a local government official, for example, who later becomes a national official, amasses hundreds of millions, if not billions of pesos, then that benefit continues today. Second, if Your Honor, please, integrity, hindi po pwedeng biyakin po yan na kesa dati ay hindi po ganon at ngayon may integridad. It's very clear that integrity is a continuing requirement of fitness for office. Thank you, Your Honor.
Duly noted and entered into the records.
Just very briefly, Your Honor.
Counsel
I
for
won't take
respondent.
much time of the impeachment
As a
court.
rejoinder to the statement and manifestation of Representative Jabna, briefly.
Thank you, Your
Madam,
Honor.
You may proceed.
I think the good counsel has already stated precisely the reason for our position. We maintain our belief that the Duterte versus HOR ruling precludes any of these trawling incursion, again, on private records of so many individuals and so many entities when nothing in the articles of impeachment point to any specific allegations as to the relevancy of all these documents, Your Honor. But nonetheless, we will include all our position and as well as our objections on the request made today with respect to these documents. And what it would seem to the defense would be another 2.0 version of a fishing expedition. May I also, Your Honor, just to clarify also the period given to us to comment on the request for subpoena, may we ask that the 5-day period run from our receipt of the copies of the documents, Your Honor.
We will make sure that the counsel for respondent will get that today.
Thank you, Your Honor.
Okay.
Before I give my comment, may I just clarify if the lead prosecutor is now making a motion to arraign the respondent accused.
Your Honor, whether this is arraignment or otherwise, the motion of the prosecution is very much consistent with the Senate rules on impeachment.
I think the question, Your Honor, is very simple.
As I have mentioned, Your
Answerable by
Honor,
yes or no, Your Honor.
Rule
Is the
7,
lead prosecutor,
Rule 9,
is the lead
Let
prosecutor
this not be a debate between the
requesting
counsels.
for the respondent accused to
Counsel
be
for
arraigned, Your
respondent,
Honor?
kindly make your comments. At this juncture, the chair would like to direct the parties to prepare for their opening statements. We will start with the prosecution. May I know from the prosecution who will deliver the opening statement and from the respondent who will deliver the opening statement? Under our rules, only one lawyer shall deliver the opening statement for either side. I presume Representative Luistro, you will deliver for the prosecution and for the part on the part of the respondent?
I will deliver the opening statement for the defense, Your Honor.
Representative Luistro from the panel of prosecutors of the House of Representatives is now recognized to deliver her opening statement for the prosecution. You may proceed, ma'am, and you have 15 minutes.
Your Honor, before I proceed, the prosecution respectfully moves for the reading of the 4 articles of impeachment and the entry of the corresponding answer or plea for each article of impeachment, Your Honor. Your Honor, this is consistent to the Senate rules on impeachment, particularly Rule 7, Your Honor, the last paragraph of which mentions about failure to appear, failure of the lawyer to appear, and failure to file answer. There should be an entry of plea of not guilty. Likewise, Your Honor, under Rule 9 of the Senate Rule of an Impeachment, which says that the person impeached shall then be called to appear and answer the articles of impeachment against him or her. In this rule, Your Honor, it was likewise provided that the name of the person appearing in behalf of the respondent should be entered into the record. And by the answer, Your Honor, it is humbly believed that it pertains to the particular plea of whether guilty or not guilty of the respondent, Your Honor. Likewise, Your Honor, under Rule 21, Your Honor, the trial of all the articles of impeachment shall be completed before the senators vote on the final question of whether or not the impeachment is sustained. It is gleaned from these rules, Your Honor, that the senators will be voting on a per article basis, Your Honor. And that is why it is the humble submission of the prosecution that there should be reading of the article and entry of the particular plea per article, Your Honor. This likewise, Your Honor, manifests our complete adherence to the mandate of the Constitution sa pagbasa po ng mga artikulo ng impeachment at pagpapasok ng sagot ng respondent, maipakita po natin sa sambayanang Pilipino ang ating pagsunod sa mandato ng Konstitusyon. Likewise, Your Honor, it upholds due process not only of the respondent but also of the Filipino people. Sa pagbasa po ng mga artikulo ng impeachment, she will be informed of the nature of the accusation against her bago pa po siya sumagot whether she is guilty or not guilty, Your Honor. Likewise, Your Honor, ang 4 na artikulo po ng impeachment ay nakabase sa iba't ibang alegasyon ng facts at iba't ibang nature of accusation or cause of action, Your Honor. And with that, Your Honor, it is perceived that there is a possibility that the plea of the respondent to each and every article will be different from one another, Your Honor. And lastly, Your Honor, this is consistent with the Senate rules on impeachment because the senator judges, the honorable senator judges, Your Honor, will be voting on a per article basis after the conclusion of the trial of this impeachment case, Your Honor.
The chair will respond. Unless the counsel for respondent would like to say something about the motion of the distinguished lead prosecutor.
Yes, Your Honor, may I comment?
The lady may proceed.
Before the presiding officer can rule on the motion or request of the lead prosecutor. But before I give my comment, may I just clarify if the lead prosecutor is now making a motion to arraign the respondent accused.
Your Honor, whether this is arraignment or otherwise, the motion of the prosecution is very much consistent with the Senate rules on impeachment.
I think the question, Your Honor, is very simple.
As I have mentioned, Your
Answerable by
Honor,
yes or no, Your Honor.
Rule
Is the
7,
lead prosecutor,
Rule 9,
is the lead
Let
prosecutor
this not be a debate between the
requesting
counsels.
for the respondent accused to
Counsel
be
for
arraigned, Your Honor.
respondent, kindly make your comments and avoid asking questions from the counsel for the prosecutor. We will recognize the counsel for respondent for comments on the motion and the manifestations made by the lead prosecutor for the House. You may proceed, ma'am.
Thank you, Your Honor. I believe I have a standing question to the lead prosecutor, and I would like to ask her for the legal basis for requiring the respondent to be arraigned today. Because, Your Honor, I note that in her request earlier and manifestations given for the respondent to be arraigned today, she cited Rule 7, Rule 9, and Rule 21. However, in Rule 7, it very clearly states that if the person impeached after service shall fail to appear either in person or by counsel on the day so fixed, or appearing shall fail to file his answer to such articles of impeachment, the trial shall proceed nevertheless as upon a plea of not guilty. Well, this rule is clear. It does not talk about any arraignment. And if we take a look at this sentence, everything here has been satisfied. The respondent accused is here, has attended through counsel. She may not be in person, but the notice given to the defense is that she may appear through counsel. Second thing is that the respondent accused was also able to file her answer. And so Rule 7 does not support the request of the lead prosecutor that the respondent accused be arraigned today. Now, on the matter of Article 9, counsel also say that the person impeached shall then be called to appear and answer the articles of impeachment against him or her. And if he or she appears, or any person for him or her, the appearance shall be recorded, stating particularly if by himself or by agent or counsel, naming the person appearing in the capacity in which or she he appears. If he or she does not appear, either personally or by agent or counsel, the same shall be recorded. And for all intents and purposes, respondent is present today through counsel. There is also nothing in Rule 9 that requires the reading of a 23-page articles of impeachment, which will be a waste of judicial time. Now, finally, under Rule 21, Your Honor. May I just correct the manifestation earlier by counsel, because it would seem to me, unless a reading of the transcript would say that I'm mistaken, but I seem to have heard the lead prosecutor claim that the voting on the articles of impeachment will be per article. Well, that's true, but the first sentence of Rule 21 says, the trial of all the articles of impeachment shall first be completed before the senators vote on the final question on whether or not the impeachment is sustained. Now, honestly, I do not see how Rule 21 is related to the motion now being requested or propounded by the lead prosecutor. And at any rate, Your Honor, given that the respondent is represented by her counsel today, and this is consistent, her appearance is consistent with the notice given and in accordance with the rules of procedure of this court, then we can enter her plea on her behalf.
The arguments of the parties are duly noted. Chair will now make its ruling. The articles of impeachment were deemed read and spread into the records when it was referred by the Senate to the Committee on Justice for the proper issuance of summons. And a plea of not guilty will only be entered in accordance with our rules in behalf of the Vice President if she does not file an answer. But in this case, she has filed an answer and in fact has appeared through counsel. Insofar as the reading of the articles of impeachment is concerned, it will be done at the final resolution of this case when it is put to a vote by the senator judges, where each article of impeachment will be read before a vote shall be taken thereon. For those reasons, the motion is denied, and the lead prosecutor, Representative Luistro, may proceed with her opening statement. Kindly be mindful of the clock, and before recognizing you, ma'am, may I remind the counsels for the parties to kindly address the chair with respect to anything and everything they want or wish to say before the court, and not to address each other. The lady may proceed. Representative Luistro, you are recognized, and you have 15 minutes for your opening remarks.
We thank the court, Your Honor.
Mr. Presiding Officer, the Honorable Chiz Escudero, the Honorable Senate President, Honorable Win Gatchalian, sa atin pong mga kagalang-galang na Senator Judges, mga minamahal na kababayan, sa loob ng bulwagan o sa labas man, mga nakatutok sa telebisyon, sa cellphone o sa radyo, sa ang sulok man ng mundo, kayo naroroon. Maraming Pilipino ang nagtatanong ngayon, bakit mahalaga ang paglilitis na ito? Ano ang kaugnayan nito sa buhay ng ordinaryong Pilipino? Lubos po naming nauunawaan ang mga tanong na yan. Sa katunayan, may isang driver na nagtatanong, paano sasapat ang kita sa pasada upang mapakain niya ang kanyang pamilya? May isang OFW na nagtatanong, hanggang kailan kailangan lumayo upang mapaaral niya ang kanyang mga anak? May isang guro na nagtatanong, paano pagkakasahin ang kanyang sahod sa dami ng utang na hinuhulugan? May isang manggagawa na nagtatanong, hanggang kailan magtitiis sa pansamantalang trabaho at kakarampot na sweldo? Sa unang tingin, maaring sabihin na malayo sa buhay nila ang paglilitis na ito. Ngunit hindi. Hindi po. Sapagkat ang usapin ngayon ay patungkol sa isang bagay na pag-aari nilang lahat. Ang kanilang pera, ang kanilang tiwala, ang kanilang karapatan na maningil ng pananagutan mula sa mga pinuno na kanilang pinagkatiwalaan. Kapag ang isang empleyado ay nagkamali ng paggamit ng pera ng kumpanya, siya ay pinagpapaliwanag. Kapag ang isang barangay treasurer hindi may paliwanag ang nawawalang pondo, siya ay iniimbestigahan. Kapag ang isang principal ay naglustay ng pera ng bayan, kahit 5,000 lang yan, siya ay pinaparusahan. Natural lamang na magtanong ang sambayanan kung ang ordinaryong Pilipino ay pinapanagot. Bakit hindi ang pinakamakapangyarihan na opisyal ng pamahalaan? Ito ang dahilan kung bakit mahalaga ang paglilitis na ito. Hindi upang usigin ang isang tao, hindi upang maghiganti sa kalaban, hindi upang manalo sa politika, kundi upang sagutin ang isang tanong na napakahalaga sa kinabukasan ng ating republika. May saysay pa ba ang pananagutan sa ating bansa? Sapagkat ang kasong ito ay higit at lampas sa sino mang opisyal. Higit at lampas sa anumang partido. Higit at lampas sa alinmang administrasyon.
Earn up to 3.75% per annum daily while you relax. Watch your money grow effortlessly with interest credited to your account daily. No missions, just pure savings. Get up to 315 pesos on your first ever deposit when you download the Bank app now.
Your Honors, the framers of the Constitution understood that there may come a day when extraordinary power would be entrusted to extraordinary office. They also understood that there may come a day when trust would be broken. And that is why they gave the House of Representatives the power to impeach and the Senate the duty to judge. Not to punish political opponents, not to settle political scores, but to protect the republic itself. That is why the Constitution declares public office is a public trust. Ang kapangyarihan ay hindi pag-aari ng sino mang opisyal. Hiram lamang ito sa taong bayan. At ito ang dahilan kung bakit naririto tayo ngayon. Your Honors, the prosecution will present exactly what the Constitution requires. Evidence. Hindi chismis. Hindi haka-haka. Hindi propaganda. At lalong hindi sokmed narrative. Evidence. Official records, financial documents, government reports, video recording, statements under oath, independent findings of institutions created by law. Mga dokumento na hindi bumoboto. Mga records na walang partido. Mga katotohanan na walang kulay pampolitika. Sa unang tingin, maaring magmukhang magkakahiwalay ang 4 articles of impeachment. Confidential fund, unexplained wealth, bribery and corruption, threat against constitutional order. But these are not 4 separate stories. These are 4 chapters of the same story. Story about power exercised without accountability. Story about public trust betrayed. Story about public office that stopped answering to the public. On the first article of impeachment, the evidence will show that more than 612 million pesos in confidential fund entrusted to the office of the Vice President and the Department of Education were dispersed transferred and liquidated under circumstances that cannot withstand scrutiny. 612 million pesos. Hindi ito pera ng gobyerno. Pera ito ng sambayanan. Pera ng manggagawa. Pera ng magsasaka. Pera ng OFW. Pera ng guro. Pera ng bawat Pilipino na nagbabayad ng buwis at nagtitiwala na gagamitin ito ng tama. The evidence will show liquidation reports supported by questionable documents. The evidence will show acknowledgement receipts bearing names government records could not verify. Names that transformed accountability into a mockery. Pananagutan na naging kalokohan. Names that insulted the intelligence of the Filipino people. Mary Grace Piatos, Milky Sikuya, Kokoy Villamin. On the second article of impeachment, the evidence will show financial transactions involving billions of pesos associated with the respondent and her husband. Billions. Hindi milyon, bilyon. At habang milyon-milyong Pilipino ang nagtratrabaho at nag-iipon buong buhay upang magkaroon ng sariling bahay, makapagpaaral ng mga anak, magkaroon ng konting seguridad para sa pamilya. Aba, bilyon-bilyong piso ang dumaan sa mga bank accounts na hindi maipaliwanag ng maayos. This article is not about wealth. This is about accountability. This is about explanation. If wealth was lawfully acquired, where is the lawful explanation? If transactions were proper, where is the complete accounting? If numbers truly add up, then why do they refuse to reconcile? On the third article of impeachment, the evidence will show bribery, graft and corruption through the distribution of cash payments and monetary gifts to officials under the supervision of the respondent. This article is not simply about envelopes. This is about institution. This is about whether loyalty was purchased rather than earned. Government cannot function if loyalty is purchased instead of earned. Kapag nabibili ang katapatan, nawawala ang integridad. At kapag nabibili ang opisyal, nabubudol ang bayan. Perhaps the greatest tragedy is where the conduct allegedly occurred. In the Department of Education. Tama po sa DepEd. The institution entrusted with teaching future generations honesty, responsibility, integrity. On the fourth article of impeachment, the evidence will show culpable violation of the Constitution, high crime, betrayal of public trust through conduct that threatens constitutional order. Among all allegations before this court, none strikes more directly at the heart of constitutional order than this one. Ito na po ang pinakamatindi. And unlike in many cases, which depends upon competing accounts, this evidence comes substantially from the respondent's own recorded public statements. The court will see them. The court will hear them. The court will judge them. Public officials may disagree. We may criticize one another. They may compete fiercely for power. That is democracy. But democracy ends when violence begins. Sa kasaysayan ng ating republika, walang vice-presidente na may kaibigan na hitman. Ngayon lang, walang vice-presidente na nagpapapatay ng Pangulo. Ngayon lang, walang vice-presidente na handang magpapatay para para lamang makaupo sa pwesto. Ngayon lang. The Constitution provides many means on how to resolve political conflict. Election, legislation, public debate, judicial review, and even impeachment. But it does not permit threats. It does not permit violence. It does not permit people entrusted with power to place themselves above constitutional restraints.
Protect your brand new iPhone 17 or Pro Max with this sleek matte magnetic case, wireless charging ready, and scratch resistant. And the best part? Order now on Lazada and enjoy super fast.
Above constitutional restraints. Your Honors, at the center of this case lies a simple question, perhaps the most important to any republic. When the people entrust power to a public official, does the public official remain accountable to the people, or do the people become accountable to the public official? The Constitution's answer is very clear. Power belongs to the people. Public office is merely borrowed, and every borrowed power carries with it the obligation to account for its use. If a barangay treasurer must account for public fund, then so must the vice president. If an ordinary public servant can be investigated, then so can the highest officials of the government. If ordinary citizen is expected to obey the rules, then surely those who govern them must obey them first. Otherwise, what lessons do we teach our children? That there is law for the powerful and another for everyone else? That accountability exists only for the weak? That public office grants immunity against accountability? Your Honors, this is not the republic envisioned by the Constitution. This is not the republic deserved by the Filipino people. Therefore, the prosecution asks only this: look at the evidence. Listen to the witnesses. Examine the records. Follow the evidence wherever it leads. Judge this case not by politics, not by popularity, not by fear, not by loyalty. Judge this case by the Constitution. Judge this case by the evidence. Years from now, future generations will not remember today's political alliances. They will not remember today's headlines. They will not remember today's slogans. What they will remember is when accountability was tested, the institutions of the Republic stood firm. They will remember only one thing: what this court did when the Constitution called. Future generations will not ask how powerful the respondent was. They will not ask how loud the political debate became. But they will ask one thing: when the Constitution called, did the Republic answer? Your Honors, this is that moment. This is the moment the Constitution anticipated. This is the moment when accountability must mean exactly what it says. This is the moment when public office must truly remain a public trust. This is the moment when the Republic must demonstrate that laws are applied equally to the powerful and the powerless alike. At matapos marinig ang mga saksi, matapos masuri ang mga dokumento, matapos matimbang lahat ng ebidensya, ang prosekusyon ay naniniwala at naninindigan. Isa lamang ang maliwanag na konklusyon. Ang tiwalang ipinagkaloob ay nilabag. Ang kapangyarihang ipinahiram ay inabuso. At ang konstitusyon mismo ang humihingi ng pananagutan. Amid the clarity of the mandate of the Constitution, political noise continues. Political squabbles continues. Political division continues. Please, let me conclude. Salus populi es suprema lex. The welfare of the people is the supreme law. Thank you, Your Honor.
The opening remarks of the prosecution through the lead counsel is duly noted.
Our premium takoy is super soft, easy to slice, and perfect for any recipe. The perfect gift.
Counsel for respondent has 15 minutes and we will give you the same latitude we gave. Counsel for the prosecution for an additional 3 minutes should you so need it. You may proceed, ma'am.
Thank you, Your Honor. Your Honors, fellow Filipinos, good afternoon. As we begin today the impeachment trial of the Vice President, and in the days ahead, this court will undertake its constitutional task of receiving and weighing the parties' evidence, and ultimately to decide whether these pieces of evidence justify either a judgment of conviction or acquittal, guided only by its members' conscience and their solemn oath to do impartial justice. The present undertaking of this court, therefore, not only carries the weight of the Constitution, but also the imprint of our nation's history, because the Filipino people have shown that they never forget. We, as a nation, never forget. But why is the act of remembering important? What does it matter to our history and to ordinary Filipinos? Because in this trial, the prosecution proposes that we unseat the Vice President elected to office by more than 32 million Filipino people, more than the number of votes cast for the sitting president, and much greater than any of the votes secured by each of the members of the House of Representatives who now are here to prosecute her and seek to undo this people's choice. Sa makatwid, ang malinaw na layunin sa likod ng mga paratang na ito ay ang pagpapatalsik sa isang vice-presidenteng inihalal ng mahigit 32 milyong Pilipino at bunga ng kanilang malayang pagpapasya. Whatever one's political persuasion is, the reality is that the prosecution now comes before this court to remove a vice president chosen by an overwhelming number of the electorate. You all have heard the prosecution say repeatedly that this is because they seek accountability, that the people have a right to hold their leaders accountable. This is not a matter of debate. Indeed, the people have a right to demand accountability from their leaders. What we have yet to hear from the prosecution, however, is this. When the Constitution declared under Section 1, Article 11, that public office is a public trust and that public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives, the Constitution does not only speak to the Vice President. It also demands the same standards from the prosecutors. Being public officers themselves, the public prosecutors and the members of the House of Representatives are also held to the same constitutional standard. And so we must remember what history tells us. This is not the first time that members of the House of Representatives have attempted to remove the Vice President, and in a manner not compliant with the Constitution. In a July 2025 decision, the Supreme Court unanimously declared in Duterte versus House of Representatives, GR numbers 278353 and 278359, that the impeachment proceedings in the House of Representatives were tainted with grave abuse of discretion, rendering the articles of impeachment that the House transmitted last year to the Senate as void ab initio. Early this year, the Supreme Court unanimously denied with finality the House of Representatives' motion for reconsideration of that decision, with a reminder that while impeachment is a powerful democratic process to call out corruption and grave abuse, impeachment can be abused, and that impeachment should never be abused to maintain the hegemonic dominance of greed by shaming those who occupy high government positions into preventing them from doing what they were sworn to do. But perhaps the most enduring reminder of the Supreme Court that we must not forget in the entire course of this trial is that, in the words of the court, the rule of law that does justice is our lodestar, and that justice includes accountability. Justice includes fairness. Without fairness, there is abuse. This fairness is what our democracy is all about. It is in light of these reminders that we draw attention to certain fundamental legal principles that we think we must not forget throughout this trial. Mga batayang prinsipyo na dapat nating tandaan sa buong panahon ng paglilitis na ito, anuman ang ating kulay o politika. If we are to be true and honest to our proclaimed values, such as the pursuit of accountability, justice, and integrity in our system of government, then we must remain possessed of an unyielding resolve to ensure that the trial and judgment in this case are done in accordance with the command of the Constitution, the majesty of the law, and the discipline required by the rules. Otherwise, those who stand in sanctimonious judgment of the Vice President will send a clear message that the law can be bent when it suits the convenience of the powerful, and that justice can be sacrificed at the altar of partisan interests. Mahalagang tandaan ang mahigpit na paalala ng ating Korte Suprema. Impeachment is not a purely political proceeding. It is primarily a legal, political, and constitutional mechanism. Ibig sabihin, kailangang naayon sa batas at konstitusyon ang anumang proseso nito. According to the Constitution, it is the Senate that shall have the sole power to try and decide all cases of impeachment. This power is not shared. The Constitution gives no other body, department, tribunal, agency, or a mere committee of any of these institutions the power to try an impeachment case. The House merely initiates, the Senate tries. Yet, we have seen the Committee on Justice conduct what its chairperson, the lead prosecutor in this case, described as a mini trial, which, as we all had witnessed, became a vast fishing expedition of alleged evidence that were not even part of the impeachment complaints under its consideration, and which the respondent accused was made to answer. In that mini trial, we saw how the purported pieces of evidence were curated to construct a narrative against the Vice President even before this case reaches trial. The articles of impeachment presented before this court as an exercise of the House's power to initiate impeachment cases are therefore, in sober truth, the product of an impermissible intrusion of clear constitutional boundaries. Over the course of the impeachment trial, the prosecution will attempt to convince this court and the court of public opinion that the allegations in the articles of impeachment are supported by materials they obtained during their mini-trial, and that evidence exists to sustain a judgment of conviction. They will claim that the notices of suspension and disallowance issued by the COA and the COA decision denying the Vice President's appeal of that disallowance support their accusations, with the release of that decision by the COA conveniently timed and coinciding with the committee hearings. They will claim that the certifications of the PSA confirm their allegation that recipients of the confidential funds do not exist, even though they listed one Mary Grace Piatos in their pre-trial brief as among their witnesses, or that the liquidation of the confidential funds in a span of 11 days was allegedly swift as to invite suspicion. The prosecution will assert that the supposed NBI findings of similar signatures across a number of acknowledgement receipts submitted to the COA are supportive of their conclusion that the disbursements of the confidential funds were irregular. What the prosecution avoided informing the public so far are these: that it was the then Secretary of the Department of Budget and Management, Amena Pangandaman, who issued a memorandum for the President through Executive Secretary Lucas Bersamin on October 18, 2022, recommending the approval of the Office of the Vice President's request for confidential funds. That the Office of the President did in fact approve that recommendation of the DBM through a memorandum from the Executive Secretary dated November 28, 2022, and signed by the former Executive Secretary Lucas Bersamin by order of the President. That on December 13, 2022, the DBM issued the Special Allotment Order number SARO-PMB-C-22-001-2004, signed by former Secretary Amena Pangandaman to cover the request of financial assistance, subsidy, and confidential funds of the OVP that, notwithstanding the impending end of the fiscal year, the confidential funds were nonetheless released to the OVP on December 20, 2022 under this documented approval process. That the COA decision is far from being final, that there is a pending motion for reconsideration of that decision, that, assuming arguendo, the COA denies that MR today, or while this trial is ongoing, as could plausibly happen under the circumstances, the respondent accused still has legal remedies available under the law and rules and can file a petition to question the validity of any forthcoming resolution of the COA on the MR under Rule 64 via petition for certiorari under Rule 65 of the Rules of Court, and more importantly, that nothing in the notice of disallowance or COA decision states any findings of supposed misuse of confidential funds as confirmed by Attorney Gloria Camora when she was asked on this point during the committee hearing on April 14, 2026. Across all other articles, the prosecution will lay a landscape of what it deems to be their evidence in support of their speculations and conclusions. We are not strangers to all these accusations precisely because this was not the first time these narratives were foisted into the minds of the general public. We have heard the same tales and stories of these accusations since 2024, when the House conducted its Quadcom hearings and most recently the mini-trial of its Committee on Justice. But what we must not forget amid all these accusations is the fundamental legal principle that the burden of proof never shifts. The burden of proof never shifts. He who accuses must prove his allegations with evidence that meets not only the degree of proof required, but also meets the evidentiary standards of admissibility, credibility, relevance, materiality, and competence. We therefore should not lose sight of the core principle that the burden of proof is on the prosecution, and unless it discharges that burden, the accused need not even offer evidence on her behalf, and she will be entitled to an acquittal. This is the law then. This is the law now. And the underlying principle for this burden of proof is simple. Under our Constitution, every accused is presumed innocent until proven otherwise. An accused has in her favor the presumption of innocence which the Bill of Rights guarantees. This also brings to fore the reality that, in the words of the Supreme Court in People versus Pagal, the individual citizen is but the speck of particular molecule vis-a-vis the vast and overwhelming powers of government, and his only guarantee against oppression and tyranny are his fundamental liberties under the Bill of Rights, which shield him in times of need. Sa madaling salita, kinikilala ng ating saligang batas na sa bawat paglilitis, ang isang individual ay nahaharap sa malalim at napakalaking makinarya ng buong Estado. At ang tanging sandigan lamang niya laban sa anumang pang-aabuso ng kapangyarihan ay ang kanyang mga batayang karapatan sa ilalim ng ating konstitusyon. Kaya't mahalagang linawin na sa gitna ng pagtatangkang ikondisyon ang kaisipan ng mamamayang Pilipino at sa gitna ng walang humpay na komentaryo sa mga pampublikong espasyo, wala pang maituturing na anumang ebidensya o aligasyon na nagpapatunayan ng prosekusyon sa simpleng dahilan na ang bawat ebidensya ay kailangang dumaan muna sa paglilitis at pagsusuri ng korteng may tanging kapangyarihan sa ilalim ng ating saligang batas. Higit sa lahat, ang anumang paglilitis ay kailangang naayon sa itinatakda ng ating batas at konstitusyon at hindi lamang sa kagustuhan ng iilang may hawak ng kapangyarihan. One might ask, why is it important that we must not forget these basic principles? The ruling of the Supreme Court tells us why. The Bill of Rights applies to the entire impeachment process because inasmuch as our court recognizes that impeachment is a political process, it reminds us that it is not a purely political process but a legal and constitutional mechanism. Thus, if we are to uphold the rule of law, serve justice, and invoke the accountability mechanism, then this court and we as a people must guarantee that all efforts to hold our leaders accountable must be done right. This we must not forget. I thank the court and the public for the privilege of your time. May God bless our country.
Opening statement.
Okay. Guys, pakinggan natin yung magkabilang kampo sa prosecution at saka sa depensa. Ito. Panoorin natin to. May sinabi si Senator Alan Peter Cayetano. Pakinggan muna natin to.
Officer ni Senator Chiz.
The impeachment trial is either fair or not fair. It's either we follow due process or we do not follow due process. It's either we follow the Constitution or hindi. Walang middle ground yun. So malinaw na malinaw sa Constitution na dapat ang presiding officer yung Senate President. Hindi totoong walang kaugnayan to sa May 1, May 13 kasi obviously may mga powers that be na ayaw yung grupo namin ang majority at mag-preside. So okay yun, na-settle yun. Because nung nagka-13 sila, si Senator Win na. But bakit mag-e-elect ng ibang Senate President? At hindi ko sila maintindihan nung bring up ko na sa tamang forum yan na bakit ang AMLA illegal na tinignan ang bank account ng 3 senador dito sa Senate. Ang sabi nila, wag i-take up dito, hindi tamang forum. So galit sila pag nagpe-Facebook ako, wag daw Facebook, kumarap daw sa kanila. Pero pagkaharap ko sila, galit din sila at wag daw i-take up dito. We cannot be blind na nagkaugnay-ugnay lahat ito. Having said that, ayaw natin maantala yung impeachment trial. That's why we're just registering a continuing objection. But I am concerned na once you bend the law, once you do not follow the Constitution, sunod-sunod na to.
So despite po ng continuing objection ninyo ay
patuloy kayo magpa-participate dito sa impeachment trial?
Yes, kaya lang nga, magkakaroon ng mas maraming question on it. In the end, whether makondik o ma-acquit ang Vice President, importante ang sinabi ng taong bayan, one, walang selective justice, two, it is precisely justice. Ibig sabihin, fair at nagkaroon ng due process. Pero apektado ang due process kung papalitan natin pati yung sino mag-preside. Kung hindi importante kung sino mag-preside, bakit nilagay sa Constitution kung sino? Bakit may rules tayo kung sino dapat mag-preside?
Senator Cayetano, sa palagay po ninyo, how should the public appreciate ito kung mga balitaktakan na nangyayari po sa loob ng impeachment trial? Because it may sound all too alien or, too gobbledygook for a
I love
lot
your
of our
question.
people. Yeah.
Because simple lang, no? People should demand better government. People should demand total accountability. So we're here, we're present, we're going to hold the Vice President accountable, but let's also hold accountable lahat ng involved sa flood control at yung iba. So kung ma-schedule natin ng 30 weeks na tuloy-tuloy yung trial, bakit hindi ma-schedule yung flood control sa Blue Ribbon Committee? Diba? So sa tanong mo, how should they appreciate? Tsagain nyo lang po, day by day, hopefully yung mga dean, yung mga legal experts ma-explain nito in a non-partisan way. Ang problema talaga, Jessica, is masyadong partisan lahat ngayon. But the point is, they can also read.
Ano ho bang balita sa flood control scam?
Wala nga eh. Dun sa magkaroon ng impartial na hearing, impartial na trial, lahat nagsasang-ayon ito na ito meron na. Pero yung magkaroon ng Blue Ribbon Committee hearing at ilabas kung sino yung mga talagang witnesses, wala. Nagbibingi-bingihan, nagbubulag-bulagan.
Tatakbo ho itong impeachment trial for over 7 months. Paano po yung legislative work ng Senado?
Tatlo ang kailangan natin sabay-sabay. Impeachment, legislation, at saka yung flood control. Pero may pang-apat, we have a creeping economic crisis upon us. Mabigat ang pananalapi ng ating bayan, mabigat ang hinaharap ng mga negosyo. So we have to find a way na isabay-sabay lahat ito.
Salamat po.
Ay, sir, ano po ang inyong pagbasa naman dito sa hindi pagpunta ng Vice President dito sa unang araw na impeachment trial?
No, you do not judge the strategy. So ang order ng court ay pwedeng ang abogado or pwedeng yung Vice President. So it's just like a election campaign. In previous election campaigns, lahat ng kandidato pumunta. Nung last election campaign, sabi ni President Marcos, mas mabuting hindi siya pupunta. So may strategy yung bawat yan eh. So kami ang titignan namin, hindi yung strategy, yung ebidensya. So it's really up to both sides. I mean, the complainants, they can be there, pwedeng wala. Diba? Basta't nandun yung panel of prosecution.
Parang it should not be taken against the Vice President.
I won't comment on that kasi dapat nga neutral kami. Ang point ko lang, it's not a legal matter, it's a matter of strategy.
Okay, and then sir, yung ngayon po nakakulong na si Senator Dante Marcoleta, nakasamahan ninyo sa minority bloc. Anong statement? Pupuntahan niyo ba si Senator Marcoleta?
Definitely, ay bibisitahin namin. Ang una, safety nila. Pangalawa, na dapat maka-attend sila. At hindi kami naniniwala na hindi nakatali lahat ito sa mga investigasyon sa corruption at sa lahat na nangyayari sa ating bansa. Common sense, tali-tali lahat to. Yung nangyari dito sa Senate ng May 11, May 13, June 3, yung pag-aresto ni Jinggoy Estrada, pag-aresto ni Senator Marcoleta, yung hindi paglabas, yung hindi pag-hearing ng Blue Ribbon Committee, nakatali lahat po yan. Hindi totoong hiwalay-hiwalay na issue yan.
And then ang gusto niyo bang mangyari? Magpetisyon ang impeachment court?
Ang gusto ko sana mangyari ay magkaisa yung impeachment court. Total, sinabi na natin na 16 to convict. So
Magkaisa
pagka
po
hindi
na-
maka-attend yung dalawa, considered ng acquittal yun. So walang mananalo doon.
Opo.
Kasi hindi nila ma-appreciate yung evidence. So pwede kaming sumulat or makipag-coordinate. When I say coordinate, hindi kausap formal na pleading sa Sandigan Bayan stating our case and asking them to allow the two senators to attend.
To attend, pero kaya lang, si Senator Jinggoy po kasi suspended pa.
Yes, pero suspended ba siya both as a senator and as a senator judge or suspended lang siya as a senator? And in case na suspended siya as both, meron namang 3 months lang yun eh. Eh yung kaso na to mahigit 3 months. So hindi ba siya pwedeng manood at makita, kasi iba yung personal nakikita mo yung witnesses at iba yung nakakapagsulat o note sa amin kung anong gusto niyang isalita.
Kahit po mag-observe kung suspended pa rin
The
sila.
reality is this is sui generis. So wala sa lahat ng libro ng batas ito at paano nga ma-apply yung mga batas sa suspension sa anti-graft. Kasi hindi naman nabasa lahat ng sitwasyon na katulad nito na ang dami na nakulong, marami pa silang gustong ikulong.
Salamat po.
Thank you.
Okay, guys. Tingnan natin to.
And in fact, dun sa answer ni VP Sara, release niya nga itong mga grounds for dismissal, particularly na void daw yung impeachment hearings na naganap dito sa House Justice Committee dahil unconstitutional, for being in violation of due process, for being a fishing expedition, etc. So, pwede yun. In fact, mas magiging orderly ang procedure kung talakayin yun sa simula pa lang, yung grounds for dismissal.
Opo. Kung sakali man, maaari ho ba ang magmosyon ang depensa na i-dismiss yung articles of impeachment laban kay Vice President Sara Duterte dito nga sa impeachment trial niya?
Pwede. And in fact, dun sa answer ni VP Sara, release niya nga itong mga grounds for dismissal, particularly na void daw yung impeachment hearings na naganap dito sa House Justice Committee dahil unconstitutional, for being in violation of due process, for being a fishing expedition, etc. So, pwede yun. In fact, mas magiging orderly ang procedure kung talakayin yun sa simula pa lang, yung grounds for dismissal.
Opo. At maaari ho ba na kung yung alinman sa apat o kahit isa man lang doon sa apat na articles of impeachment ay mapatunayang walang sapat na ebidensya, ay po pwede ng pagbotohan ng mga senator judges kaagad at desisyonan kung po pwede na siyang i-convict o i-acquit doon sa kaso na yan?
Well, doon sa Senate impeachment rules, ang nakasaad doon ay tatapusin muna lahat ng articles of impeachment bago magdesisyon. Pero pwedeng magkaroon ng pagkakataon na kung ang tingin ng prosecution ay na napatunayan na nila ang isang article na sapat na para makonvict si VP Sara, pwede nilang sabihin sa court na hindi na nila tatalakayin yung ibang articles at isasubmit na nila sa botohan itong articles na or article na tingin nila sapat na para sa conviction. Pero ang tingin ko, ang personal na opinion ko, hindi nila gagawin ito dahil number one, mahina naman yung lahat ng articles of impeachment para sa akin, mahina eh. Pero number two, tingin ko mas favorable sa prosecution na patagalin itong impeachment para maaraw-araw na naman nilang masiraan itong si VP Sara bago eleksyon. So kumbaga, kung hindi man nila ma-convict si VP Sara base sa ebidensya at base sa botohan ng Senate, nasiraan naman nila araw-araw for 60 or 90 days si VP Sara bago mag-eleksyon. At dahil doon, baka mas humina si VP Sara sa 2028.
Oo. So attorney, nasabi mo na mahina yung apat na articles of impeachment. Wala po kayong nakitang possible na loophole na possible na magiging tagilid sa isang articles of impeachment itong si VP Sara?
Para sa akin, kung legal ang pinag-uusapan, strictly legal, hindi po papasa sa korte yung articles of impeachment at yung mga ebidensyang napakita na so far dun sa House impeachment hearing. Pero like I said, hindi lang ito legal, political din ito. So titignan natin ngayon kung anong mangyayari.
Alright. Attorney, siguro yung huling mensahe para sa ating mga kababayan na nanonood po at nakikinig sa mga oras po ito.
Okay, guys. Naka isang oras na po tayo mahigit sa ating live stream. So, yon. Guys, napanood natin yung iba't ibang yung opening statement ng prosecution sa pamamagitan po ng kanilang lead prosecutor na walang iba kung hindi si Representative Jervil Luistro ng Batangas ay nagbigay ng kanyang opening statement. Samantala ang defense panel ng kampo po ni Vice President Inday Sara Duterte sa pamamagitan po ni Attorney Sheila Sison ay nagbigay din ng kanyang opening statement at talaga nga naman kompleto at magaling ang kanyang pasok, guys. Wala kang makikitang pamumulitika. Hindi katulad po sa aking opinion, ha. Hindi katulad po like ng kay Congresswoman Luistro ay halatang halata na may pamumulitika, halong pamumulitika yung kanyang opening statement. Ang kay Attorney Sheila Sison ng Depensa ay puro po may kinalaman sa batas at saligang batas o konstitusyon na may kinalaman po sa impeachment trial. So muli po, nagpapasalamat tayo sa mga nagbigay ng kanilang mga komento at opinion dito po sa ating live stream ngayong gabi. Ang oras po natin ngayon ay alas 10:18 na po ng July 6, 2026. Ngayon po ay gabi ng Lunes, bukas Martes. So muli po, magandang gabi sa inyo lahat. Pagpalain po tayo ng puong may kapal.